Hi, everyone, and thank you for joining today's webinar on what to know about equity after layoffs. Before we get started, we need to kick off with some legal disclaimers. This communication is on behalf of eShares, Inc., doing business as Carta, Inc., a global management platform, global ownership management platform, and registered transfer agent with the U.S. Securities and Exchange Commission. This communication is not to be construed as legal, financial, or tax advice, and is for informational purposes only, and not for the purpose of providing legal advice. This communication is not intended as a recommendation, offer, or solicitation for the purchase or sale of any security. Carta does not assume any liability for reliance on the information provided herein. The content in this communication is for informational purposes only and does not constitute a comprehensive description of Carta's tax advisory services. Also, please feel free to drop questions in the Q&A tab at any time. We left some time at the end of the presentation to go over pre-submitted questions as well as any questions added during the presentation.
Hello. Hi, my name is Nicole Sturman. I'm a senior tax advisor here at Carta. I'm an attorney by background, barred in the state of California, and I specialize in individual tax advisory and consulting. And I will pass it to Jackie to introduce herself.
Hi, everyone. My name is Jackie Ammon, and I lead business development efforts for Carta's secondary liquidity and public markets products. Prior to joining Carta, I was also a lawyer. I practiced corporate law, helping companies navigate business and legal issues associated with all aspects of running a business, raising capital, and exits. Okay, so today we're going to cover the top things you need to know about equity compensation if you've recently left your job. First, you should understand the basic information related to your equity. Usually this means finding your equity agreements from when you first received your stock, and then identifying what type of equity you received. We'll cover the most common types of equity issued to employees later in the presentation. Next, make sure that you read the agreement to determine any applicable vesting schedules and post-termination exercise periods attached to the equity. We're going to help you identify that in a minute too. Next, and most importantly, make an informed decision about what to do with your equity. This is crucial. It's not just about deciding to take action or not with respect to your equity. It's about understanding the tax consequences and financial implications of that decision. Nicole's going to spend a lot of time on that shortly. And finally, if you choose to take action, make sure you are doing it in a timely manner. For some types of equity, you have to take action within 90 days of departure from your company, or you will lose certain tax benefits.
We do want to emphasize here that equity and tax decisions are not a one-size-fits-all. Each person has a different perspective from a cash, tax, and risk standpoint, so it's really important to do what's right for you personally.
Okay, so before we dive into the different types of equity that you may hold, it's going to be helpful to review some basic terms applicable to that type of equity. We're going to cover these concepts a number of times during the presentation, so if it sounds repetitive, that's on purpose. First is vesting. A vesting schedule is attached to almost all equity grants because it incentivizes certain behaviors by the holder. Vesting means the holder earns the right to buy and own the equity when certain conditions are met, and you'll be able to find this in your equity agreement. The second is the exercise price. This applies specifically to stock options and is the price per share in amount that you'll pay to exercise your stock options once they've vested. You'll also be able to find this in your equity agreement. Next, the post-termination exercise period, or sometimes referred to as PTEP, is the length of time you have to exercise your stock options after you leave a company. This is typically 90 days, and we'll explain why in a bit. The board, in certain instances, has discretion to extend this all the way to the expiration date. You'll be able to find the expiration date as well as the PTEP in your option agreement. So the expiration date is the last date outstanding stock options are valid under the plan. As I mentioned, you can usually find this in your stock option agreement. It'll also be in the stock plan docs that are associated with your grant. And the final glossary item for now is a company right of first refusal. So this is something most companies implement and require of all common stockholders as well as option holders. And it's baked into the terms of your equity agreement. So what does this mean? Let's say you hold common stock and you want to sell it to your friend for $3 a share. A company right of first refusal says that before you sell it to your friend, you must first give the company the opportunity to buy that same amount of stock at $3 per share. If the company opts to exercise this right, then you have to sell it to the company on those terms. If the company declines, only then can you sell it to your friend.
All right, now we're just going to talk about the type of equity that you could have received. And this will sort of guide your decision-making around your equity. So there are two types of equity: one, stock options, and two, restricted stock. Stock options are a contract to purchase a certain number of shares at a certain price. So if you were granted options, you weren't granted shares outright. You were actually granted the opportunity to purchase those shares for a certain price. Restricted stock, you receive shares outright if certain conditions are met. And I'll talk through examples of these conditions in a few slides. So now let's dig deeper into the different types of stock options you could have received. One being incentive stock options and two being non-qualified stock options. Incentive stock options is what's usually reserved for full-time US-based employees, whereas non-qualified stock options can be awarded to basically everybody else. The main difference between incentive stock options and non-qualified stock options are the tax at exercise. For incentive stock options at exercise, we need to think through something called alternative minimum tax. If this is unfamiliar, that's pretty common. I'll go through what that means when I talk through tax implications. For non-qualified stock options, this is just subject to ordinary tax, the tax that we see basically every year on our tax return. There are also two types of restricted stock, one being restricted stock awards, and then the next being restricted stock units. Restricted stock awards, these are stocks that are awarded at grant subject to a vesting schedule. With restricted stock awards, you are able to file what's called an 83B election, and I'll talk about the advantages of this when I talk through tax implications. With restricted stock units, you don't receive shares at grant, you actually receive the promise to receive shares at some later date based on whether certain conditions are met. Because you are not receiving shares at grant, you cannot file an 83B election with restricted stock units. So now I'm going to go into a little bit of the process when it comes to your stock options. So exercising only applies to stock options. Remember, with stock options, you're granted the opportunity to purchase shares, right? So exercising your options is just a fancy way to say purchasing shares. With your stock options, you have to take this action in order to receive shares. Because you have to purchase these shares, you need to know the price that you have to pay for these shares. That's where your exercise price or strike price comes into play. These two can be used interchangeably. Your exercise price is the fixed price you pay for one share of your company's stock. And you can find this information in your equity grant agreement. So let's take a look at our example equity grant agreement. This is our friend Iris Ward here, and we're looking at her incentive stock option grant. So we see here that her exercise price is $1. So that means if Iris wants to exercise one option, she's going to pay $1. She'll receive one share in return. The most common question we get around exercise price: will my exercise price change? The answer is no. Once you accepted that equity grant agreement, that strike price or exercise price is locked in. It's always going to be the price you pay for one share of your company's stock. Now, if you received more than one grant during your time at your company, it's very likely that those came with different strike prices. And that's because these strike prices are set by the current fair market value of the shares on the day you were granted the options. This fair market value is set by what's called a 409A valuation. A 409A valuation is an independent appraisal of the fair market value of a private company's common stock. So this fair market value is what usually sets the strike price for stock option grants. A company needs a new 409A valuation, a new fair market value every 12 months. So you know that a private company will have a new 409A valuation, a new fair market value at least annually. The other time a company will need a new fair market value is after some sort of material event. The most common material event we see in this space is just raising another round of funding. So now I'm going to chat through vesting when it comes to stock options. Jackie talked a little bit about this, but when it comes to stock options, vesting is just earning the right to exercise your options, earning the right to purchase those shares. Typically, it's just working at the company for a period of time. So if we take a look at our example equity grant agreement, we'll see that her vesting schedule is 4 years with a 1-year cliff. Now, what does that mean? That means after Iris has been at the company for 1 year, she hits her 1-year work anniversary, which is her 1-year cliff. At this point, Iris will vest 25% of her options. She will have the opportunity to exercise 25% of her options. After she hits that 1-year cliff, she will continue to vest monthly until she hits her 4 years, where she will be fully vested in all of her options. Common questions around option vesting. Do I need to report anything while I'm vesting? While your stock options are vesting, there is nothing to report. There is no tax associated. The only time you will have to report anything when it comes to options is at exercise. And then another common question we get basically is this an all or nothing thing, right? If I vest 25%, do I need to exercise all 25%? You're not required to exercise 100% of what you vest. It's all up to you, your personal decision. This is usually when I tell this story, I had an employee come up to me in a one-on-one and she had never held stock options before. Her favorite number was 17. So she exercised 17 options, right? So it really is dependent on you, your personal financial or tax picture, and maybe what your favorite number is. Okay. So when it comes to restricted stock, vesting is a little bit different, right? Vesting basically removes the company's repurchase restriction. So for restricted stock, vesting allows you to keep your shares without the risk of the company buying them back. When it comes to restricted stock awards, usually time-based, similar to that vesting schedule that I was talking about with those stock options. So as time goes on, restrictions lift and you own those shares outright. So more time spent at the company, more shares owned. When it comes to RSUs, restricted stock units, vesting can either have a single or double trigger vesting. Single trigger is just time-based, similar to those previous examples, and most public companies have this single trigger vesting. For double trigger vesting, this means that the company has 2 separate vesting conditions, usually time-based vesting and then event-based vesting. So usually you have to work at the company for a period of time and then some sort of event has to happen. Usually we see an IPO or an acquisition. So if you look at the language here, you'll see that her vesting schedule is 4 years plus a liquidity event. So even if Iris has been at the company for 4 years, she will not receive shares until the company goes IPO or is acquired.
Okay, so now let's talk about some non-tax related considerations related to the equity you may hold. And Nicole covered some of this, but let's go into some granular detail. First is stock options. How do you know if you have stock options and whether they're incentive stock options, ISOs, or non-qualified stock options, NSOs? You would have likely agreed to a document with a title like grant notice or stock option agreement, and you would have heard buzzwords like strike price when you received your grant. As mentioned before, if you're an employee, you could have received ISOs or NSOs. So check your agreement to confirm the type of equity. And it might be different if you have multiple grants. If you're a contractor or an advisor, you are only eligible to receive NSOs. And so that's what your agreements should say. The important thing to note about stock options is that there's affirmative action you need to take after leaving the company, or else you may lose the equity in its entirety. So if you have not yet met any of the vesting milestones in your ISO, then you cannot exercise anything upon termination or departure from the company, and there's nothing for you to do related to that equity. If you have vested in part or all of your ISO, you have 90 days from the date you left to exercise your vested options. And Nicole's going to cover the reasons for that shortly. The same general idea for NSOs. If you have not yet met any of your vesting milestones in your NSO, then you can't exercise anything upon termination or departure, and there's nothing you need to do upon departure related to that equity. If you have vested in part or all of your NSO, you typically have 90 days from the date of termination to exercise that. But that's less tax driven for NSOs than in the context of ISOs, which we'll go over shortly. So if you hold an NSO and you need more time to gather the money required to exercise, you can, in certain instances, ask the company and the board of directors to extend your post-termination exercise period, but it's at their discretion. You should ask your company contact about extending the PTEP on your grant if you think you need more time to exercise. But again, remember, that's at their discretion. They don't have to do that. Once you've decided to exercise your ISOs or NSOs, you're going to need to pay the aggregate exercise price for the vested shares. So what does that mean? That equals the total number of vested options on the date that you left, multiplied by the strike price per share. If your company is on Carta, you can exercise directly through the platform. If not, you should look at your grant agreement and follow the instructions there. And that may mean that you need to mail a physical check to the company contact listed on there. Once exercised, you own those shares outright as a company stockholder. Okay, so now let's talk about restricted common stock. How do you know if you have this type of equity? You would have signed a document with a title, something like stock purchase agreement, and you would have paid for the stock when you received it. So you sent a wire, you gave a check, something like that. Money changed hands when you signed that paperwork. And as Nicole mentioned, you likely filed an 83B election as well around that same time. If you are fully or partially vested in your restricted common stock, then there's nothing you need to do to remain a stockholder of the company with respect to that vested stock. Just make sure that your contact information remains current with the company so that they can contact you in the future related to stockholder matters. If you have not fully vested, the company likely has a right to repurchase any of the unvested stock. If they decide to exercise this right, they will remit payment to you for the aggregate repurchase price, which is usually the price that you paid at the time of purchase, just for the portion that's only unvested. You would have already agreed to this repurchase right with respect to the unvested stock when you signed the original stock purchase agreement, so you can't decline this payment from the company. It's automatic. Now let's talk about restricted stock units, or RSUs. How do you know if you have them? You likely agreed to receive them by signing a notice of RSU grant. If you if you were an employee of a public company, you almost certainly held RSUs. You did not pay anything out of pocket when you accepted the grant of RSUs. As Nicole mentioned, if you have single trigger RSUs issued either by a private or a public company, and again, single trigger means that the stock is only subject to one type of vesting condition, and that's normally the time-based vesting, you're going to continue to own whatever equity you vested in and settled in as of the date that you left your company. You do not need to pay out of pocket to settle the stock, though you likely owed taxes as you vested. And Nicole's going to cover that again in a second. Whatever single trigger RSUs are unvested as of the date of your departure, don't settle, and you just lose them. They don't vest or settle, and they're gone. If you have double trigger RSUs, so this is the likely scenario if you were an employee of a private company. That means, as Nicole mentioned, there's not only a single trigger, one vesting condition that's usually time-based, but there's also a condition that there needs to be some kind of equity event for you to vest and settle your stock. And the exit event is going to be an IPO or an acquisition. So if you were an employee of a private company and you had double trigger RSUs, then it's more likely than not that you have not vested in anything with respect to that RSU, because by definition, they're private still and they haven't had an exit. There are certain limited instances where a company could opt to waive the liquidity trigger and allow your stock to vest as if it was just single trigger time-based vesting. But this is, again, a really company-specific decision, and almost all companies opt not to do it. If that's the case, you're going to lose any equity subject to a double trigger RSU. Okay, so as I mentioned earlier, it's important to know that if you decide to take action with respect to your stock options, you have to do so within the time prescribed by your equity documents. This so-called window of time, again, is called a PTEP, or a post-termination exercise period. So for vested ISOs, you have 90 days from the date of departure to exercise the vested options, or they will be forfeited. The 90 days is statutory. It's set by Treasury, IRS, so it's mandated. If your company extends your PTEP for an ISO, you still have to exercise within 90 days in order to get the ISO tax treatment. And any ISOs exercised after 90 days from departure of the company are going to be taxed as NSOs. For vested NSOs, check your grant agreement for the post-termination exercise period window. And as I mentioned before, if you need more time to make a decision or to gather the funds to pay the aggregate exercise price, you can ask your company to extend the PTEP on your grant for NSOs. They're not required to do it. It's at their discretion, but some companies will if there are compelling reasons to do so. And here's some data related to PTEPs from CARTA companies showing that over the last a few years, approximately 10 to 15% of companies have extended PTEPs beyond 90 days. You're going to see an even larger amount, 25% in Q2 of 2020. And that was the beginning of the COVID-19 pandemic when a lot of layoffs were occurring. And so there's a bump up because people were extending the PTEPs beyond 90 days, kind of in connection with those layoffs.
Okay, now for the fun stuff, taxes. So I'm going to go through each equity type and talk about the related tax. So for restricted stock awards, without an 83B election, you'll pay tax on restricted stock awards as they vest. So essentially, because there are restrictions, because the company has the ability to buy back this stock, in the eyes of the IRS, you don't own them outright until those restrictions are lifted. So at the time of vesting, the difference between the price you paid and the current fair market value is going to be considered ordinary income, subject to ordinary tax rates. If you filed that 83B election, which is very likely at the time of grant, then there won't be any tax at vesting, because an 83B election tells the IRS, no, I don't want to be taxed at vesting. I want to be taxed at grant, where my price was equal to the value of the shares. So likely no tax implications when you were granted, and then no tax implications to worry about as you vest. Okay. For restricted stock units, remember these shares, you were unable to file an 83B election because you didn't receive any shares at grant. You'll pay tax when the shares are actually issued to you. When you meet the requirements to own the shares, the fair market value of the shares that you receive will be treated as wages, will be treated as ordinary income subject to ordinary tax rates. When I say ordinary tax rates, think about the tax rates for which your wages are subject to. So usually with RSUs, because they are treated as wages, there's a withholding that needs to be applied. Same with RSAs, but usually there's no tax implications there. This withholding can be covered either by employees' cash payment, withholding shares, sometimes, or with public companies, there may be the ability to sell some shares to cover the tax due. It really depends on your equity grant agreement, how this withholding will be covered. So be sure to check that equity grant agreement to see how this withholding would be covered. So Incentive stock options. So this one is a little bit different than the rest. When you exercise your incentive stock options, you could be subject to something called alternative minimum tax. It is not very common to see it on your tax return. So if you've never seen it before, that's totally fine. It's good, actually. So every year on your tax return, you have your regular tax calculation, the tax calculation you see on like the first 2 pages of your tax return. So your regular tax is calculated. On a separate form in the background, alternative minimum tax is calculated. Whichever is higher is the amount you're going to pay. Usually, there's really nothing to trigger this alternative minimum tax calculation. So year after year, people don't normally see it. But in the year that you exercise your incentive stock options, the spread between your exercise price and the current fair market value of the shares is included as income for this alternative minimum tax calculation. So in the year that you exercise your incentive stock options, you could have some additional tax due. Now, because you only pay this tax, this alternative minimum tax, when it's higher than your regular tax, there is an instance where those numbers are exactly the same. I like to call it a sweet spot, but we call it the AMT break-even amount. So it's basically the amount of income that we can include in your AMT calculation without triggering the tax. So that's something that you can find. There's an AMT calculator on Carta, but there is a way to exercise your incentive stock options without triggering tax. And I will mention, if you live in any of the states listed on this slide, you also have a separate state AMT calculation to think through. So for non-qualified stock options, this is subject to regular tax, similar to those RSAs or RSUs. That spread between your exercise price and current fair market value is going to be considered wages, subject to ordinary tax rates. Again, there's going to be withholding applied, similar to those restricted stock tax implications. Because this is actually considered supplemental income, all of these incomes, it's actually going to be subject to a flat rate federal withholding of 22%. It'll also likely, if applicable, be subject to a flat rate state withholding, and also payroll withholding will apply. With NSOs, usually when you receive wages, right, you receive cash, your company withholds that cash. With NSOs, there's actually nothing to withhold on. So at the exercise of non-qualified stock options, you are responsible to pay in that exercise cost plus any withholding due. I want to take this time to mention that if you do not exercise those ISOs within 90 days, but you have a longer PTEP than 90 days, those options will be treated as NSOs. So Jackie mentioned this a little bit. So you can see how, if you were able to exercise outside of those 90 days, that'll change your tax implications around exercise. There's not a way to play around with tax due if there's a spread with non-qualified stock options. I just want to quickly talk about how sales are taxed, because what you're receiving with these equity awards eventually are potentially shares in a company. And so a lot of people think about, the future and potentially being able to sell these shares at some point. When we think about how sales are taxed, first, we have to think about the capital gain or loss, which is just taking the sales price less cost basis. For ISOs, this cost basis is just your purchase price, your exercise price. For NSOs, it's the fair market value on the day you exercised. RSUs, fair market value on the day you received those shares, on the day they vested. RSAs, price paid at grant if that 83B election was filed, and then fair market value if no 83B election. The next thing you have to determine is whether this is a short-term or a long-term capital gain. This is just based on holding period. Short-term capital gain means you received the shares and sold within 1 year. Long-term capital gain means you receive the shares, waited a year, and then sold. And that will dictate the tax rate applied to the gain. Short-term capital gains are taxed at ordinary rates. Remember, like those wages are taxed at. Long-term capital gains are taxed at preferential or lower rates, 0, 15, 20%, depending on your income level for the year. Okay, so if you received stock options, you have to take some sort of action around your equity grant. So what we like to think through here at Carta is an exercising framework: cash, tax, risk. Really weighing the importance of these three can help you in your decision-making around exercising your options. Cash. How much are you looking to spend between exercise and those related taxes? Are you a little bit liquid right now, or are there other things in your life that you need to allocate this money to? Tax. How important is tax efficiency? Should the tax tail wag the dog? Really, it's just thinking through whether tax is your driving force behind your decision-making, or are there other things to consider as well? And then risk. This tends to be the most difficult one for people to think through. It's very personal. It changes a lot from person to person. But some of the questions you can ask yourself are, where do you see the company going? Where do you see the value of your shares going? Are you comfortable with the idea that you may not be able to sell these shares anytime soon? If you're exercising options and receiving shares in a private company, you can't just turn around and sell them like you would public company stock. And then, are you comfortable with your asset concentration? Really weighing these things, thinking through all of these questions can help you in your decision-making around your option grant. And I want to look at this maybe through an investor lens, right? Usually we hear high risk, high reward, but I want to emphasize it is a higher risk to purchase shares in a private company, right? You can't turn around and sell these shares right away. You're making an investment that kind of has to sit on your shelf for a little bit. And the reality is, not all startup companies succeed. So it's really important to assess your personal risk appetite before making a decision around your option grant.
Okay, so next we want to just share some data insights for those of you who might be looking for your next endeavor. So not surprisingly, Silicon Valley still reigns over venture capital. But according to the Carta data, companies at the earliest stages are making moves in other markets. So flexibility in the geography outside of traditional emerging company and venture capital markets might be helpful for you if you're looking for a new job, particularly in this post-pandemic era where remote and hybrid working schedules allow employees a broader range of options of locale. But what geographies specifically are providing the most new opportunity? So if you look across all Carta's companies, ranging from seed investments all the way to pre-IPO, California, as I mentioned, still maintains traditional dominance in terms of the amount of cash invested in those companies. However, when you focus down on just seed investing, so kind of the earliest stage startups, the picture is a little bit different. California's share of the seed investment cash is only about 38.5%, which is a dramatic drop from the 48% share that it holds in terms of all venture capital investment in companies. So which states are rising? Mostly Florida, if you look at the map. The Florida share of total investment has jumped from 2.3% in all of VC to 9.9% when you're looking only at the earliest stage companies. Other states like Texas and Illinois are also taking a fair share of these early round investments. Also, make sure when you're looking for a new job and a new opportunity that you really understand how valuable your time and your knowledge are and how that translates into compensation in the current market. While salaries in the current macro conditions are not moving up quite as dramatically as they have been, say, for the past few years, they're still incrementally increasing, and they certainly may have been higher than the last time that you were looking for a job. And depending on where you live, you may have access to recently enacted pay transparency laws, which allow applicants better visibility into compensation for the roles they're applying for. So in New York, this means employers must include salary or hourly wage ranges on any advertised role. In California, starting in 2023, employers must include salary or hourly wage ranges for internal or external job postings. The key here is really to make sure that you are prepared when you enter the job market to advocate for yourself, and make sure you do that by researching and asking questions both in your own network and of the potential employer you're talking to.
There are a few articles on Carta that dive deeper into employee equity facts. We encourage you to take a look and kind of do a little reading for yourself. They're available on Carta's website in the blog section.
Carta also has some additional resources free to you at any time on our website that you can see listed here. There's an employee resource center dedicated to helping you learn information about equity basics, including the AMT calculator that Nicole mentioned, if you want to calculate that, if you're thinking about exercising options. We also have an Equity 101 video series that breaks down a lot of the equity and tax concepts that we talked today on the webinar, as well as data reports that provide more data insights in the current state of the markets, if you're interested in that as you look towards your new endeavor. And then we've also included a link to Rora's salary negotiation consultation service, if that's of interest.
Okay, that's it for this part of the presentation. Now we're going to look through a couple of questions. And I know some of you have been putting in questions during the presentation. We'll take a look at those. Feel free to ask to add more questions now as well. Okay. So let me just bring those questions up. Okay, Jackie, do you want to answer the first question?
Sure. So the question was, is there a standard time of year, calendar-wise, that a company needs to issue a new fair market value via a 409A? The answer is, there's not a specific time of year. It depends whenever they got their first 409A. So if you got your company got their first 409A in April of 2020, pending a material event happening in the interim, they will have needed to get a new 409A April 2021, April 2022, et cetera, every 12 months from the first one. As Nicole mentioned, material event will require a new 409A, and for most private startup companies, a material event is going to be a fundraising round. So they would normally get a new 409A within a couple of weeks of closing that round.
Okay, I got a question. Can I find my PTEP and expiration date in my Carta account? Yes, it's right there in your Carta account. All you have to do is click into your equity grant. Once you click in there, it'll show how long you have to exercise. And then you can take that. Also, your expiration, like if your PTEP is until the expiration date, you can also find your expiration date when you click into your option grant. So it's all on Carta if you have a Carta account. Go ahead.
Do you want me to, I can grab the next one. So this question is, if you exercise private company options post-termination, how can you turn that into liquidity if an IPO or acquisition is not imminent? So Nicole kind of mentioned this in terms of like your risk assessment, and if you're deciding to exercise options, the short answer is there isn't a lot of ways. I mean, that's the risk, the high risk, high reward thought process that we're talking about. You may never be able to liquidate those shares into cash. And if you do, you may have to wait, a while. So that is something that you need to factor into your decision making. It's not the end all be all, but as Nicole mentioned, I like this phrase, like you got to be ready to put that equity up on a shelf and wait for it.
Yeah. Yeah, and yeah, like Jackie said, that's just one of the things that you have to think through with that cash tax risk framework. It's just one of the risks of, exercising options or holding equity in a private company. Okay, let's see. I have equity in a private company that fully vested earlier this year. I was laid off a few months later. What do I need to do? So first thing, that's kind of what we were talking about. First thing you have to do, determine sort of what kind of equity you hold, right? If there's any action you even need to take. So if they're restricted stock, really nothing for you to do. It's all based on that vesting schedule, whether you receive these shares or not. If they are options, you will have to take a look and see what your post-termination exercise period is. Once you figure that out, you can kind of determine how much time you have in order to exercise those options. And then that's when it kind of falls on you to decide, think through that exercising framework, decide whether you want to exercise your options, while also knowing that you really don't have to do anything, right? Like it really is, I've said this a ton, but it really is up to you, your personal tax picture, your personal financial situation, and how you feel about the company. So really just going through that steps, type of equity, how long you have to make the decision, and then working through that exercise framework.
Awesome. So this is a really interesting question, and Nicole, I want you to chime in on this, because I think this is a question a lot of people have. How do you know the fair market value of your stock options when you exercise? So we've talked a lot about, your strike price, right? That was told to you on the date that the option was granted to you, and it's in your stock agreements. The short answer is, I'm sure Nicole gets this question a lot. The short answer is the company knows the fair market value and has to tell you. But Nicole, how do you see this play out in real life?
Yeah, it's tough. I mean, okay, if you have a Carta account, super easy. It is on your Carta account. Really awesome. It's right there. Yeah, if you don't, it's where you kind of have to go ask your company what the fair market value is of those shares. It's not something that is readily available to people outside the company without an ask, unfortunately. So it might be where, you have to kind of go back and just ask what the current fair market value is and when it expires.
Awesome.
Go ahead.
No, you go.
If I exercise an ISO for a pre-IPO company, then hold that exercised option for 12 plus months and then sell it privately, assuming no IPO has occurred, will I pay long-term capital gains or short-term capital gains, assuming there's a gain? So before I go into this, I do want to say, if you exercise options for a private company and receive private company shares, there are several restrictions to selling these shares. It is not like a public company where you kind of have free will to sell as you please. So if you are thinking of selling privately, you do have to go through the company and get approval, which I'm sure has happened, but I don't see it very often. But, just from a tax perspective, if you exercise your options, hold those shares for over a year, then yes, that will be a long-term capital gain, assuming there's a gain, and then those lower tax rates would apply.
All right, so here's another question that might have been generated from a question earlier, but what happens when there is no market to sell our shares? In other words, the strike price is the fair market value before a company has a liquidity event. I think the main thing we want to emphasize here, what happens if there's no market to sell your shares? If you hold stock in a private company, almost by definition, there is no market for you to sell your shares. It's not, as Nicole mentioned, it's not like the public markets. You can't just kind of freely sell through your Schwab account like you would other stocks. This is intentionally, there is no market for these shares. And so you have to hold on to them until a liquidity event occurs. And if you remember kind of earlier in the presentation, I said, if you hold vested stock in a company and you're an actual stockholder, it's important to keep your contact information current. So if that's with a Carta account or the company secretary, because they'll reach out to you when it's time for a liquidity event to happen. And so that will be your opportunity if and when a market presents itself. And again, it's important to emphasize, there may never be a market for private company shares. So you may exercise the stock and purchase it and hold it, and nothing ever happens. That is a possibility. It's an unfortunate possibility, but it's a real one.
Okay. if I am in a public company, can I exercise my options directly on Carta? You can only use Carta if your company uses Carta. So, and you'll know because you'll receive a notification from Carta when you received your equity grant. If you have not, and if your company doesn't use Carta, you're unable to do so. It's only if the company hosts its capitalization table within the Carta platform.
Okay, so we got another question. So to confirm, if you were laid off before any of your equity vested, they're all gone. Yes, effectively. I think, again, like go through all the steps that we told you about, find your equity documents, read them, like really double check all of that. If your company manages their cap table on Carta, go look at your Carta account and see what it says. But the short answer is yes. If you haven't vested, you lost, you didn't, you're not going to receive anything when you leave the company.
Yeah. Okay. If my ISOs are fully vested and the PTEP is longer than 90 days, is there a framework you recommend for deciding whether to let the ISOs convert to NSOs or to exercise before they convert? I think the biggest thing to think about here is whether there is a spread between your strike price and the current fair market value. I think that's the first thing to determine, because realistically, if there's no spread, then there's no difference between the two, because that's what the tax is based on. If there is a spread, then what you want to consider is, because you do only have those 90 days, try to figure out essentially how much tax would be generated from each instance, right? Like because you have a certain amount of options that you have available to you. So you can kind of figure out what the tax would be if you exercised either one. And then that's when I would think about the cash that you have on hand, right? So if you have the cash on hand to exercise within your PTEP and the tax implications are something bearable, maybe you would want to think through exercising while you're in that 90 days. But if you don't have the cash on hand and you have a longer PTEP that allows you to exercise past those 90 days, maybe you don't have the cash on hand, maybe you don't want to take the risk right now and you have a long time to decide. Maybe it's worth it even if the tax is higher or different with those NSOs. Maybe it's worth it to just hold off. So again, it really is just going through that exercising framework again, thinking through the differences in those taxes and whether you want to pay that cash out of pocket now or maybe hold off. So I think it just goes back to thinking through that cash tax risk.
Okay, so this next question. I come from a scenario where my equity is in options that I need to purchase from a pre-IPO company, meaning private, with no line of sight to an IPO. The options are expensive. And what scenario should I consider if I intend to purchase these options, but I'm not comfortable with tying up a lot of capital for not a guaranteed return? I mean, this is like the ding, ding, ding question, right? It's exactly what we're talking about. It's a very personal decision. And like, Nicole, I'd love you to chime in here too. I think a couple of things to think through. We can't tell you what to do. As Nicole mentioned, you should think through the framework of what she said and decide what's most important to you personally. A couple of things I would recommend though. The first is if you don't care about getting ISO treatment, if you hold incentive stock options and you don't care about the ISO tax treatment, you should ask the company to extend your post-termination exercise period to the expiration date. That just gives you the benefit of more time to make this decision without limiting you to, say, the 90-day window that ISOs are limited to. And a lot of time NSOs are limited to 90 just because the company does that to keep it consistent among all stock options. So that's the first thing I'd recommend is ask the company to extend your PTEP. And the second thing that you should think about, and Nicole kind of mentioned this earlier in the presentation, is you don't have to exercise everything. Right? If it's prohibitively expensive for you to fully exercise all of your vested options, you don't have to do that. You can exercise up to the amount that you're comfortable with given your personal finances. So again, like we can't make this decision for you. We're giving you the framework and the tools that you need to make a decision based on what's important to you personally. But those are two things that I think you can consider that give you a little more buffer and time to make a decision, or you don't, because as you said, there's not a guaranteed return, maybe only exercising a portion of the vested options jives better with the risk that you're willing to take. I don't know, Nicole, if you have any other thoughts.
No, I really couldn't have said it better myself. Yeah, it really is. I want to emphasize this because people do think that it's an all or nothing thing, and it's just not, right? Like you can, if you have a certain amount available to you, you certainly don't need to exercise all of that, right? Like you don't need to allocate all of that cash to exercise everything you have. But if you believe in the company, right, or you're okay with the risk of maybe tying up a little bit of cash that you have, then maybe that's worth exercising a smaller amount than you have available to you. So I do want to emphasize that. Yeah. Okay, great. It looks like we've chatted through most of the questions. I think we're going to leave it at that, but I'm happy that you all spent some time with us talking through equity after leaving the company. And we were happy to be able to present to you. So thank you.
Thanks, everyone, and good luck.
Yes.